Ship arrest in Turkey. As a part of preparation for EU membership, Turkey is in the process of amending or promulgation its primary and secondary legislation. Within this framework, the long-pending Turkish Commercial Code, a key element for the accession negotiation, was promulgated on 14 February 2011 and entered into force on 1 July 2012. New TZZ. Turkey's commercial code regulates the maritime matters as well as other areas of commercial transaction and shall radically amend many aspects of Turkish maritime law, including arrest of ships. This article outlines the new ship arrest rules and procedures under the new TZZ. Turkey isn't a party to any of the international convention on the arrest of ships and the existing domestic law before the enactment of the new TZZ didn't have specific rules on this matter, and the arrest of a ship was in general terms no different than any other conservatory measure or conservatory attachment of any other asset of a debtor. Theoretically, a ship could be arrested for any claim whatsoever, whether maritime or not. In other words, theoretically, the possibility to arrest a ship wasn't limited to maritime claim provided that there was a prima facie evidence about the claim and the risk of securing it. In practice, however, the court were very reluctant against ordering conservatory measures. Most of the court rejected such application based on ground that the claim in question requires judgment. Due to the restrictive application of the cautionary measures by majority of the court, the claimant's lawyer tried to file their application for arrest before certain courts which were more liberal in granting such measure, even though the ship may not be within the jurisdiction of such court. Another important problem with respect to the previous arrest practice was that the counter-security requirement differed significantly from one court to another. Some of the courts require counter-security in the amount of 10% of the claim amount, while some others could require as high as 40% of the claim amount for exactly the same claim and under similar conditions. All those factors led to a great variance in the arrest practices in different parts of Turkey, although theoretically the same rules had to be applicable. The new TZZ. The committee that has prepared the new TZZ looked the arrest rules of various states such as England, Germany, US, South Africa, as well as International Arrest Convention. The arrest provision of the new TZZ mainly reflect the provision of the International Convention on the Arrest of Ships 1999, even though Turkey isn't a party to the aforesaid convention. In addition, relevant provision of the International Convention on Maritime Liens and Mortgage 1993 are also reflected in the new TZZ. The new TZZ aimed to bring a full and unified set of rules dealing with all aspects of arrest of ships and to tackle the special need of the different parties in maritime transport. Applicable law to the arrest procedure. The provision of the new TZZ that deal with arrests are applicable to both Turkish flag and foreign flag ships. It is nearly undisputed in Turkish practice that the court should apply lex fori with respect to the conservatory measure, including arrest and enforcement proceeding. The new TZZ follow this well-established principle and explicitly provide that the procedure relating to the arrest and release of a ship shall be governed by the law of the state in which the arrest was effected or applied for. So, in the event that an arrest application is made before the Turkish court, the court shall apply Turkish law with respect to the arrest procedure even there is a foreign element. The application of the Turkish law, however, shall be limited to the procedural matter. The law applicable in the merits of the dispute shall be determined in accordance with the Turkish conflict of laws rules and may be a foreign law. Claims in respect of which a ship may be arrested. According to the previous arrest rules, arrest of a ship in Turkey could take place for all type of claim, regardless of whether the claim has a maritime character or not, or whether it is connected with the ship to be arrested or not. Under the new TZZ, a ship may only be arrested in respect of a closed list of 22 maritime claims which are enumerated exhaustively, but in respect of no other claim. Maritime claim aim in respect of which a ship may be arrested are under the new TZZ are the same as those listed in Article 1 of the International Convention on the Arrest of Ships 1999. Loss or damage caused by the operation of the ship, loss of life or personal injury, salvage, damage or threat of damage to environment, wreck removal, any agreement relating to the use or hire of the ship, any agreement relating to the carriage of goods or passenger, loss of or damage to or in connection with goods carried on board the ship, general average, towage, pilotage, good materials provision, bunkers, equipment, including containers, supplied or services rendered. Construction, reconstruction, repair, converting or equipping of the ship, port, canal, dock, harbor and other waterway dues and charge, crew wakes, disbursement incurred on behalf of the ship or its owner, including the loan obtained for the vessel, insurance premium, any commission, brokerage or agency fees, any dispute as to ownership or possession of the ship, any dispute between co-owners of the ship as to the employment or earning of the ship, a mortgage or a hypothec of a chart of the same nature on the ship, any dispute arising out of a contract for the sale of the ship. The only difference is related to Art 1 of the Convention. According to Art 1 refers to claim arising out of disbursement incurred on behalf of the ship or its owners, whereas the corresponding provision of the new TZZ reads disbursement incurred on behalf of the ship or its owners, including the loan obtained for the vessel. The reference to bank loans has been added pursuant to the demand of the Turkish Bank Union Association. The new TCC doesn't provide an explicit provision as to what law shall be applicable in determining as to whether a claim is to be classified as a maritime claim within the meaning of the code, but based on the well-established court of the appeal precedents, which is followed in the preparatory work of the new TZZ, it can be stated that this issue will also be governed by Lex Fori. Thank you.